office has in fact extended an offer to the defendant in this case to plead guilty to capital murder and a sentence of life without parole and a complete waiver of all of his appellate rights in exchange for us no longer dropping the death penalty in this case. This was not a decision that was reached lightly or hastily. This is something that has been ongoing for a discussion that has been ongoing for several months. It's something that I personally have thought about very much so. I believe in the death penalty. I believe that this defendant deserves the death penalty for what he did. I campaigned on continuing to seek the death penalty in this case. And today, this morning, last night, our office and myself, we've received numerous calls and texts and emails that are express anger and confusion and betrayal. And I've received text messages from close friends and family members asking what happened, what changed. And the answer to that, what changed was I sat down and spoke to the victims personally, each of them individually. And we asked them what they wanted out of this process and what they wanted to see done. And it was very clear as we met with the families, one by one, that there is a strong and overwhelming consensus that just wanted this case over with, that wanted finality in the court process. Starting in January, when we took office, we began immediately setting up individual meetings with all of the families that were willing to meet with us. And I say willing to meet with us because there are, in fact, some families that have been so turned off by this process that they want nothing to do with it anymore, that they have entirely checked out. But we made efforts to meet with families one-on-one, which is something that had not been done in many, many months. This office had group meetings, Zoom meetings, but I will tell you, some of the families that I was meeting with in January and in February, I was the first district attorney that they had sat down with and spoke to individually. And over January and February, we met with the families individually, and we explained to them what this process would entail if we continued to seek the death penalty. As you know, there was a tentative scheduling order that we would begin, or we would attempt to begin a trial here in El Paso next January of 2026, where we would attempt to pick a jury here. And I have long believed that a jury of El Pasoans should be the ones to decide this defendant's punishment. I believed that before, I believe that to this day. But I expressed to the families that I did not have great confidence that that was going to be possible. That I felt that there was going to be a challenge to find 12 fair and impartial jurors here in El Paso who hadn't already made up their mind about what the appropriate punishment should be. And that, in my opinion, in my professional opinion, there was a fair likelihood that we would have to move the venue for this trial. That would add to the delay. We discussed the fact that there was still a tremendous amount of pretrial litigation that was left to be done. And in fact, we're still engaged in it now. Pretrial litigation that could take months or years. Realistically, the January 2026 timeframe was, in my opinion, not realistic. I think we were looking at late 2026, 2027. I could see a worst case scenario where this would not go to trial until 2028 if we continued to seek the death penalty. And of course, this is on top of all the other delay that this case has been beset with since 2019. why we are here at this point, we can't change it, we can't control it. There are certainly individuals who are more responsible for this delay than others. COVID is a significant portion of that delay. And after speaking with the families and giving them this assessment and speaking through with them what they truly want out of this process, as I mentioned, it became very clear that the vast majority of them want this case over and done with as quickly as possible. That's not to say that there aren't family members that did not want the death penalty. There certainly were, and I do not begrudge them at all. I completely understand. I am in agreement with them personally. A number of family members who wanted the death penalty, wanted us to continue seeking the death penalty no matter how long it takes, despite decades, 20, 30, 40 years of potential appeals. But after weighing it all and speaking to even the survivors who were there, who were injured or who were shot at, meeting with them, over that 3-month period of January, February, and March, we met with over 50 individuals, victims, their family members, and survivors. It became untenable for us to continue. I could not, in good conscience, continue to seek the death penalty against the wishes of so many of the victims. It's that simple. That's what changed. We still have a month to go until the plea. We anticipate, or the judge has entered a plea hearing and sentencing on Monday, April 21st. That was a date that we requested. It will give us sufficient time to coordinate the travel for the out-of-town families that would like to be here and express their thoughts at the sentencing. But I felt that it was urgent in light of the questions that we were getting from you all and from the community to address why this decision was made. And as a result, we moved to vacate the gag order that has been in place. Judge Medrano vacated the gag order this morning, and that is why we are here now. And I'm willing to take any questions from you all. Bob.
Mr. Montoya, you mentioned the factors that have led to the delay. I'd like to ask specifically about the actions of one of your predecessors, Yvonne Rosales, and people associated with her, Roger Rodriguez and Curtis Cox. How much did those efforts complicate the prosecution of this case, and how much did they weigh on your final decision?
Sure. Well, I will tell you, in my opinion, the personnel decision that Ms. Rosales made at the start of her term, when she came in here and terminated close to a quarter of the entire office, including lawyers, victim services personnel, investigators, secretaries, receptionists. At that time, she dismissed the entire team that was working on the Walmart case in 2019 and in 2020. I think that had a tremendous impact on the case. At approximately the same time, the federal government was pursuing its concurrent prosecution. And when the case came back to the state court after the U.S. Attorney's Office and the Department of Justice pled out the case, when the case came back to the District Attorney's Office, it seems clear to me that they were not prepared for that. And they basically had to start the case from square one. And eventually they got started on that process, and then we had these efforts to tamper with witnesses in Mexico, to tamper and impersonate certain victims' families. It really breaks my heart that a representative of this office, a representative of the state of Texas, engaged in that misconduct. At the end of the day, it doesn't change the facts about this case, and her conduct as a whole contributed to the delay, but the misconduct that her and her colleagues engaged in, to me, weighed very little in the ultimate decision of bringing this case to an end.
Mr. Montoya,
Aaron.
I think it's safe to say a lot of interest in hearing what exactly happened that day, would have been spelled out in trial. What is your message to, the El Paso community, but anyone who is interested in seeing, just justice being delivered in this case?
Yeah, I mean, I know some folks wanted to have a trial for closure, and I don't discount that. I believe in trials. I think jury trials are the most important and fundamental aspect of our criminal justice system. The trials that we engage in every single day are very informative because they give us guideposts as prosecutors and defense lawyers on how this community feels about crime. And as I mentioned earlier, I have long believed that we needed a jury to decide this case. But in my opinion, the benefits of having a trial to the detriment of the families was simply not worth it. There are other ways for the public to inform themselves once the case has been disposed of on what happened. As you know, there's Public Information Act requests that you all can seek if you want to publicize portions of the investigation. I will tell you that multiple victims' families expressed concern to me that that would happen. They do not want that. They do not want their loved ones' last moments broadcast on the news. They do not want to see a Crime Channel special about the Walmart massacre. They do not want to see that. Now, I leave that up to you all whether, you have statutory rights under the Public Information Act. I hope that the representatives from the media will be cognizant of I believe in the role that you all do. I think it's really important. I think it's important that this community knows the truth of what happened that day. And that certainly would have come out during the trial. There are other avenues for that to come out. But again, I urge anyone who considers that the weight and the effect that would have on the victims and their family members.
Can you speak to the kind of penalty now that you all will be seeking then, if not the death penalty?
Sure. So it's an automatic life without parole. This defendant will die in the penitentiary. He will not get out. He will die in prison. And fundamentally, that's what this comes down to is, are we going to drag this out for a year, 2 years, for decades, so that we can stick a needle in his arm? Really? He will die in prison. There is no doubt about that. And is it worth it to put all of these folks through that to make it go a little bit quicker? And like I said, in good conscience, I could not tell these victims' families that we were going to do this despite their wishes.
Is he going to stay here, or is he's going to be taken to another prison?
Well, the plea hearing is scheduled for April 21st. There will be a court proceeding here in this courthouse where he will plead guilty. He will be sentenced by the judge to life without parole, and we will have impact statements from the victims' families. Once that is done, there's some paperwork that needs to be processed, but for right now, because the state of Texas originally brought the charges, he would originally go to the Texas Department of Criminal Justice, TDCJ. As you know, there is a concurrent federal sentence, 90 consecutive life sentences. There's a recommendation by the federal judge that he serve those sentences at the U.S. Penitentiary Supermax in Florence, Colorado. As many of you know, that is that is the highest security correctional facility in the entire country. It is where we send ISIS, Al-Qaeda. It is where we've sent El Chapo, major drug traffickers, spies, traitors. It is the most secure correctional facility in the country. However, that is just a recommendation. And even if we agree or put in the plea agreement that he serve his sentence at a particular place, the ultimate decision on where he will serve his sentence will be up to the prison authorities. And so that will be between the Texas Department of Criminal Justice and the Federal Bureau of Prisons. They have the final say on where he will serve a sentence. They don't have to listen to us, they don't have to listen to the judge.
James, related to that,
Oh.
you would have had to prove future dangerousness
Right.
in the trial.
Right.
I'm sure you've already imagined the defense coming up and talking about Supermax and how he's going to be buried in a hole there and can't
Right.
be of danger. So I guess the question for you is, do you believe that Patrick Crusius remains a danger to society? And do you believe that he is a racist bent on harming Hispanics?
I think he is filled with hate in his heart. I think that the beliefs that he harbors, that motivated him to come here and commit the worst terrorist attack against Latinos, against Hispanics in the United States, I think that is what makes him dangerous, harboring those beliefs. He himself, as a person standing, is not a danger. I have sent people to the penitentiary who are, in my opinion, much more dangerous than he is. But if you ask me, do I think he is an escape risk? I do not. As you alluded to, one of the common misconceptions in a death penalty case is that the jury just votes life or death, which is not accurate. The jury is asked two specific questions. The first question is, can the state prove beyond a reasonable doubt that there is a probability that the defendant will continue to commit criminal acts of violence that constitute a continuing threat to society? It's what we call the future danger question. The state, we, have to prove beyond a reasonable doubt that the defendant in that particular case is a future danger to society. The jury has to unanimously answer that question, yes. Yes, he is. There's a second question, what we call the mitigation question, which is there anything about the defendant, his background, his upbringing, the circumstances of the offense, including his mental illness, that would warrant a sentence of life without parole instead of death? So we call, again, the mitigation question. The jury would have to unanimously answer that question, no. No mitigation. Yes, future danger, no mitigation would equal a death sentence. If one juror answers either of those questions differently, it's a mistrial that automatically results in a life sentence. There is not a retrial. It automatically results in a life sentence without parole. And so, Bob, to your question, were there concerns that if we had a trial, how would we have proven future danger? Again, in my opinion, what makes him dangerous are the beliefs that he holds. Reyes.
Considering that he's already been sentenced in a federal court to
Mhm.
90 consecutive life terms,
Mhm.
you want us to determine what the state's punishment is that state time? Is that served concurrently, or how?
So the state sentence of life without parole will, in theory, run concurrently with the federal sentence. There's nothing in the federal sentence that says it runs consecutively to the state sentence, and so by operation of law, the presumption is that both life sentences run. The federal sentence will, the presumption is that the federal sentence runs concurrently with the state sentence.
Can you talk to us about what survivors and family members who, lost loved ones are saved from by not going to trial, and the conversations you had with them?
Yeah. Yeah, the biggest thing is the delay. These families have been in limbo for 6 years. 6 whole years. And like I mentioned earlier, there are some families that don't even care anymore what happens, because at the end of the day, what we can accomplish in the courtroom is not going to fill the void in their hearts. It's one of the hardest parts of this job, is meeting with El Pasoans, with members of this community who have lost loved ones, who want to feel whole, who want to feel better. And sometimes they look to this system to make that happen. And that is not what the system is for. It is designed to hold people accountable. And, speaking to them, to me, it was just so overwhelmingly clear that what they wanted was finality, that they just wanted it to be over. They didn't want to be getting calls from us anymore. You know, they didn't want to be, you know, I started these conversations apologizing to them that I'm the fourth DA that they have to meet over the last 6 years, that I'm sorry that we're even having to continue meeting. And many of them expressed gratitude for having the meeting, for hearing them out. I will tell you, some family members expressed that they did not feel like they had been heard by some of my predecessors about what they wanted out of the case. And so I think that's how they felt. I mean, you know, the gag order's lifted. They are free to speak about it. We've advised them that they can speak about it if they want. They do not have to. You know, it is completely up to them when or if or at all that they want to make their feelings known. But I feel like in our conversations, in our one-on-ones, it was very clear. So.
A couple questions. First off, do you feel any regret that comes with this decision? And then what goes through your mind when people tell you that they're not happy about this?
Yeah, I do not regret this at all, one bit. After having talked to the families yesterday, you know, we had conversations about how they felt, what they wanted to see, you know, just yesterday afternoon is when we made the notification that this was my decision. And the gratitude that was expressed by multiple families, I mean, only confirmed to me that this is the right decision, this was the correct decision. Speaking to them, I will tell you, gave me even more confidence that this was the right decision. No regrets at all.
And then when people express their anger about this decision,
Yeah.
what does that mean?
Yeah, you know, I mean, that's why we call this press conference. You know, I want this community to know that this decision to withdraw the death penalty, it's not about the evidence of the case. We were going to convict him 100%. If we were to proceed to a trial, and I think it is very likely we would have gotten the death penalty. It's never a guarantee. Like I said, one juror could have held out and said, I believe in the mitigation, or I don't believe he's a future danger. That would have been it. I feel confident we would have succeeded in obtaining a death verdict had we gotten to that point. We just don't know how much longer that would have taken. And so I understand the frustration. I completely understand where the community is coming from. I completely understand why my constituents feel the way that they do. I get it. I know some people feel that this is a betrayal of the victims. And I want to make this very clear that in my opinion, we are following their wishes. And again, I don't want to discount this though. There are victims' families who wanted to pursue the death penalty all the way into the end, no matter what. But the overwhelming majority did not. So, Reyes.
Can you speak in any way to the likelihood or whether you heard something about a future civil case against Walmart?
You know, I know some civil cases were filed. I have not kept up with them at all. I have no idea how this disposition affects their case at all. I've never practiced civilly. This has always been my heart and soul is criminal law, and so I know that there is one. I have no idea what impact this will have on it.
And if a civil trial were to occur, would all the same evidence that would have been in the criminal trial, would that also be?
I don't know. I can't say. Bob?
James, looking ahead, at some point, this office is probably going to pursue capital punishment against another defendant out there. I can imagine a defense attorney turning to the jury and saying, this office would not seek the death penalty against a man who murdered 23 people. Why are they seeking the death penalty against my client? How do you respond to that?
Sure. And if not him, then who? Right? I mean, if we're not going to do the death penalty against someone who came here and killed 23 and injured 22 in a racist, hate-filled attack, why have the death penalty? And it's a question that I struggle with now. I tell you, I think he deserves it, personally, for that reason. My thoughts on the death penalty are, it really boils down to I think Texas gets it right to the extent that our capital sentencing scheme focuses on future danger. If we can, to me, the death penalty is appropriate for the types of people who are going to continue to be dangerous even in prison. People who attack other guards, defendants who attack other inmates, defendants who, because they belong as part of an organized criminal group, you know, that they are able to coordinate violent activity out in the free world from where they are inside of prison. To me, those are the types of people that are deserving of the death penalty. You know, we have had cases here in this office in the past where people who were pending trial for capital murder were attacking guards, were breaking down doors at the jail. You know, in the Facundo Chavez trial 2 years ago, you know, one of the clearest who murdered Deputy Herrera, this time 6 years ago as well. You know, one of the key pieces of evidence in his sentencing phase in the future danger was shortly after he was arrested, or several weeks after he was in the jail, when they did a pat down of him, he had a copper wire under his collar, right, that could have been used, or we believe was going to be used as some type of weapon. That's the type of evidence that we look for in future danger. Is this someone who's been to the penitentiary that is not reformed? Is this someone who has no regard for the corrections officers or their fellow inmates? And so, you know, as I said, I believe in the death penalty. You know, when this happened in 2019, we had 3 pending capital murder cases where we were seeking the death penalty simultaneously. Before that, it had been, I think, 6 or 7 years before we had sought the death penalty previously. When the next capital murder comes up, and it will come up, we will assess and evaluate each case individually.
I do feel like we need to talk about this, and I want to give you the opportunity to address it. But
Sure.
You yourself admitted that you run your campaign leaning towards seeking the death penalty.
Yeah.
And you know, this was attack that killed 23 people,
Mhm.
killed 22 others, but it was a racially motivated attack
Mhm.
that was against people that looked like most of our community.
Right.
What do you have to say to the people who now feel betrayed and maybe even misled by this decision?
Yeah, the circumstances, not even the circumstances, I met with the families. It's that simple. That's what changed. I'm telling you, to this day, right now, I think he deserves to die for what he did. That is my personal opinion. But that, you know, I'm the community's elected representative. I'm these families' representative. And I cannot tell them to their face, after having these conversations with them where they have told me that they want this case over with, for me to tell them, I hear what you say, I understand it, but nah, we're gonna keep doing this. I am not gonna do that. Just not gonna do that. And I understand that this community feels strongly, and we wanted the death penalty against him, and I told people that we would continue to seek it. And once I met the victim's families, that's what changed. And I hope this community will understand.
You mentioned that some of the family members did want to continue to seek it, no matter how long it took.
Right.
Did some of those family members reach out after this decision with any anger or disappointment?
Well, I called them to let them know, and they expressed how they felt during the conversation. You know, some of them vehemently disagreed. I thought most of the conversations they understood. And all I can ask for is that they understand where we are coming from. So, one last question. All right.
Can we talk about the timing of this? You know, we just had a mass shooting this weekend. Community obviously still very raw. A lot of people are reliving those moments. Can we talk about why the decision to talk to the families on Monday and make that?
Sure. Well, we had some hearings that were coming up. We're still engaged. Well, there was still substantial pretrial litigation that was going to happen in the next few months. We were seeking to appeal and unseal some of the orders that the judge had sealed, and we were coming up on those pretrial hearings. And I wanted to speak to these families as quickly as possible and make this decision as quickly as possible for them. And it was a priority of mine since taking office. We started meeting with these families in January and February, and so March was always kind of the goal. So thank you all so much. We really appreciate your time.